Chief Justice, we approach this court with your permission as amicus curiae.
You still need your 10 minutes, or is it going to be 5? I'm in your hands.
I think it's going to be 5.
Okay.
Yes. In our submissions, what we seek to propose to this court, having regard to the fact that we are faced with a national crisis, and further to that, there is the very uncomfortable aspect that a private institution or private institutions can hold the state, as it were, to ransom in a contract. Where blame lies, I do not wish to discuss. But what is the fundamental aspect of how does a state provide services to the most marginalized in our society? And in having regard to that, SAPO has come out with an alternative, which it says it's an organ of state. It can provide an alternative solution. The issue that was bandied about was that CPS was the only party capable of carrying out this task. The South African Post Office has indicated that it is equally capable of carrying out that task. Now, the question that we want, and we would support and we want this court to promote, is the idea that where there are intergovernmental organizations and organs of state, that those organs of state, if they are capable of performing of the functions, and if they are properly capacitated, and if they have the sufficient resources, that organs of state need not look out to private institutions. This is in promoting the Constitution. It is also promoting the values that are set out in the Intergovernmental Framework Act. And what the court is currently sitting with and faced with is an issue of an illegal contract that needs to be extended. On the one hand, it has its legal questions as to whether this court is capable or should or has the necessary powers from a legal framework. And then the second element are the practicalities. And we're submitting that we fall within the area of the practicalities. And as an assistance to this court, we have therefore produced what we believe is a report that was submitted as an RFI, which produces and shows that the South African Post Office is capable. In fact, the South African Post Office currently operates through Postbank 6 million accounts. The current accounts are close to 12 million, although there are over 17 million beneficiaries. So an account operates on the basis that there may be more beneficiaries attached to an account. It is also important to note from our perspective and from the court's perspective is that CPS itself is not capacitated enough for it to carry out the functions. It has in fact subcontracted other parties to carry out its functions. So it is not like CPS goes in terms of its CIT, it uses Fidelity. In terms of its banking, it uses Bidvest. So these are these are issues that can be dealt with, and SAPO has presented its version and its solution that it submits should be taken into account by this court, and coming to a solution that would be in the best interest of the country. I just want to quote from the judgment, if we just keep in mind that SAPO had entered into a letter of agreement prior to CPS coming on board. And that letter of agreement was with SASSA in 2009. And it is the subject matter of the case, which is the Chief Executive Officer of SASSA and others versus Cash Pay Master, which we've quoted in our heads of argument. So what happened in those circumstances was that SAPO was providing and is currently providing for over 500,000 beneficiaries in the Eastern Cape. And while it had entered into a letter of agreement, Cash Paymaster then challenged that letter of agreement between SASSA and Cash Paymaster. Leave to appeal was then granted, and SASSA and SAPO then took it to the Supreme Court of Appeal. At the Supreme Court of Appeal, it was held that there was no need to go out on tender, and that the deviation could be applied for if there was a rational basis. And we submit there is a rational basis in this, at this juncture.
Mr. Bava,
Yes.
That the principle strikes me as a sound one. Do you have an admirable track record in terms of service delivery to build onto?
Yes. I noticed that there is a tinge of laughter around, but
forget about the laughter.
Yes,
it's you and I engaging.
Yes, sorry, Chief
because they will laugh, and then you'll be distracted from your submissions.
I preface that because it shows a perception, and that is why it's important for us to look at it as well. There are two aspects. One is SAPO itself, and then there's the division of SAPO called Post Bank. Post Bank makes about 20 million payments per month. During all these disruptions with the post office itself, Post Bank was not affected. Post Bank runs approximately 5.6 million accounts. Now that is fundamental. It is also in the process of applying to become a bank, and that is to be done by July this year. But that is neither here nor there, because that doesn't talk to anything. What it does show, though, is that Post Bank has got the track record. SAPO itself has been paying these 500,000 beneficiaries in the Eastern Cape for the last 10 years. So what happened in this case that came, and Chief Justice, I just want to quote from what the Supreme Court of Appeal said, and it gives us a sense of the factual element and the factual encapsulation of what we are dealing with when we say that there's only one service provider out there who can provide these services. He says, one is unfortunately left with a lingering impression that Paymaster's motive in wanting to have the letter agreement set aside is to perpetuate the expensive cash payment system, and not because it is concerned about the costs to SASSA of the payment system, or because it is a possible bona fide competitor of Post Bank. Paymaster is not a registered financial institution, or financial service provider, or bank, and it cannot on its own provide the services which Post Bank offers. Paymaster admittedly, well, it continues, but the point is fundamentally that the Supreme Court of Appeal has recognized, having regard to the fact that you have got a private institution which itself is subcontracting. Now, why is that not possible? And we submit, and we have put the proposition on the papers as Post Bank and SAPO are able to render the services in the process of a month. 1 month. If it's necessary, it has an electronic voucher system which it can implement, and going further, it can then provide a service equivalent to the entire system, which we said would take a rollout of about between 9 to 12 months. So what happens is that and just as an aside, CPS has said that the 20 rand per beneficiary quoted by Post Bank and SAPO is exceedingly high compared to the 16 rand 64. And their current estimations, CPS's own, are with inflation, they'll go to 22 to 25 rand. You've heard earlier the submission from Mr. Unterhalter that has a differential of between 800 million to 1.2 billion rand differentiation. But the point is fundamentally, at the end of the day, is that the 20 rand that was presented as a CPI by Post Bank was a system which would come into operation that is more advanced than what CPS can provide. Now, this is the solution that was presented. This is the solution that is being presented to this court as an alternative. And it is one that if this court is to agree with the submissions by the SAPO and to place it on the following proposition, that if the court has any element of discomfort, that the court may ask that there be a wind-down procedure as opposed to an extension. Now, it may be a semantic difference, but the question is, does that pose as a solution? Can a solution, sorry.
Now, is SAPO not a state-owned enterprise or entity with a political overseer in the form of a minister?
Yes, it is.
Is it fair to assume that that being the case, through the minister responsible for this portfolio, Postbank SAPO can just take this to cabinet and say, stop worrying, here is a solution within a month, there won't be any problem. You don't need these people. Is it something that can, in other words, that can be sorted out within government circles without court intervention?
Having regard to the history of this matter and as it currently stands, it is difficult to say. It does have, in terms of various legislations, that ability to do and to take it to Parliament and to have that presented as an alternative. But they are two separate ministries. In this circumstances, here what the court is faced with is the fact that there is a ministry that for whatever reasons has not concluded an agreement when it ought to have. And SAPO's view is that if there is a court order to the effect, it will short-circuit and provide a solution that will be to the benefit of the state and the beneficiaries.
A court order to what effect?
A court order to the effect that the illegal contract comes to an end, a wind-down process be engaged with, and that SAPO or any state entity, but in this case SAPO is the one that can show that it has the ability, that it engages with CPS and SASSA in order to get the contract to continue the service provisions.
Do we have the power to do that, to prefer Postbank or SAPO?
I do not see why not. I do not see why the highest court in the land, having regard to this crisis that is facing the country, cannot do so.
Did amount to judicial overreach?
Not from where I stand.
Mr. Bava, we may have the widest possible powers under Section 172, but I'm not sure that we are omnipotent.
Mr. Bava,
Yes.
if my brother Justice Matlanga is through, I'm just troubled by your capacity,
Yes.
Mr. Bava. SAPO has been paying 500,000 beneficiaries per month in the Eastern Cape, as opposed to the numbers we are talking of in this matter of 17 million grants. Do you think you have the capacity?
Thank you, Justice Kambeve. If we are to take Postbank and we are to analyze that there are these 17 million beneficiaries, there are only close to 12 million accounts, which means that, for example, a beneficiary, let's assume there's a family of beneficiaries. So it would be 3 that would be linked to one account. So currently CPS operates close to 12 million accounts, although there are 17 million beneficiaries. Postbank has 6 million accounts. So it is not that just the 500,000 beneficiaries that it services on a voucher system, on an electronic voucher system, it has capacity in terms of operating bank accounts like a bank would. And it could also, there's nothing precluding SAPO from subcontracting with those entities like Bidvest, Fidelity Security for the cash in transit. There are 10,000 points set up by Fidelity Securities for CPS. 10,000. And these go into cash areas like community halls or some places in rural areas where there are no facilities. But this is not managed by, this is not done by CPS. It is done by Fidelity CIT. So why is it that SAPO cannot take those, and we submit that they can, take those, subcontract those parties and provide the services? If the court finds that there is discomfort in the time period of 1 month or 2 months, a period of 3 to 6 months may also assist and will also be in terms of a wind down. But if that is the wind down procedure that we're looking at, the court can oversee rather a wind down and a handover process as opposed to sustaining this. The element sustaining the contract, this will create an element where the court says, for whatever reasons, there was a conclusion or the finalization of the contract is at 31st March 2017. And the only process that has not been accommodated for is a wind down and a handover, because there is no information that we have unless CPS comes and says that they have in fact engaged in.
You see, Mr. Bava, I'm just worried by the fact that as a first proposition you are saying 1 month. It strikes me as something overly ambitious. You've got to put, I'm not a business person, and yes, to use the South African lingo, I'm not an entrepreneur.
Yes.
So I don't know much about how these things work, but I rely on logic, on common sense. You've got to put systems in place.
Correct.
To be able to reach out to people, not just in 9 provinces, in certain cities, but even in the rural places like my own village.
Correct.
So how then do you get to that point within 1 month? I assume that whatever proposal you put forward is born out of proper reflection, a proper study of, for want of a better expression, the market.
Correct.
You know what it will take to deliver quality service to the people without an apology. Oh, I'm sorry, I thought it would happen, but I missed out on some step. No.
Yes.
So how do we then begin to take SAPO seriously if it says within 1 month it would be able to do this?
Yes. Chief
when
Justice,
it hasn't even entered into any contract with anybody?
Firstly, let me say that I agree that there is no room for excuse where it deals with 17 million beneficiaries. It's not something that can be taken lightly. Hence my suggestion that while I personally have sat with the technical team at Postbank, and not that I have any qualifications in that regard, they have assured me that they will be able to take over the system in 1 month. That was the proposal they made to the CEO of SASSA on the 1st of March in the letter. And this is with the technical team, and that is why my suggestion, if there is discomfort by the court, which there must be, because we're dealing with such a huge element, that if there is one missed payment, it has disastrous consequences.
I assume that the following would be a fair summary of the proposition. Whatever happens in the future in relation to this project, SAPO or Postbank must not be disregarded, or the possibility of SAPO or Postbank assisting the process must not be dismissed lightly.
Yes.
It's a serious contender to be seriously considered. Is that the fair summary of the submission?
It goes beyond that, Chief Justice. It is not just a submission of wanting to do future work. It is not wanting to come out, the second element, at a profit, because all the monies that Postbank or SAPO makes goes back to the state. So it is not in that vein that we are competing for the work or submitting that we should be the preferred bidder. for want of a better word. That is not what we're submitting. We're submitting as SAPO that there is a crisis in this country, that this crisis needs to be dealt with. We still do not know what CPS is going to be saying, because there is this, our law up to now has been that the courts do not make a contract, they enforce a contract. Now, how
Mr.
does
Baba,
one...
may I interrupt you?
Sure.
I think the Chief Justice very graciously offered you a deal,
Yes.
and I think it was a good deal. And I don't think you're engaging with a good deal that he offered.
Thank you, Justice Cameron. It is sometimes when we talk that we forget to listen. I say that SAPO needs to be taken into account in the consideration in the future. But I'm saying that if the crisis heightens, that it is not left to a situation where the state says they do not have a solution. For example, if CPS decides commercially to retract and says that we have a constitutional judgment, but we believe that we're going to come with more constitutional challenges on that constitutional element, then we're going to be finding that we'll be caught up in court and 17 million people, beneficiaries, will not be paid. SAPO is standing in the wings. That is what we are saying.
Thank you, Mr. Bava, and
Thank
your
you.
time is up.
Thank you.